All right, so good afternoon and welcome to today's webinar, The Ethics of Divorce in an Injury Lawsuit. I'm Cassie Seaton and I'm the Outreach and Marketing Manager here at Stritmatter. Our firm was started 75 years ago in Hoquiam, Washington, and we still have an office there as well as our main office in Seattle. 3 of our partners of our firm are former presidents of the WSAJ, and our namesake partner, Paul Stritmatter, was also the president of the Washington State Bar Association. A significant portion of our practice involves partnering with other lawyers on major personal injury and wrongful death cases. The WSBA has licensed the Stritmatter firm as a sponsor for mandatory continuing education and approved our seminars for credit. You'll receive 1 free ethics credit for today's webinar. So please stick around at the end and I'll ask you to put your bar number into the chat. I'm going to include the written materials in the chat, and then I encourage you to ask questions in the question and answer box. Our presenter today is Gemma Zanowski. She is a partner here at the firm. Gemma has tried multiple cases to verdict in bench and jury trials in federal and state court. Gemma's current practice focuses on complex civil litigation. She is a member of the legal team and representing over 50 peaceful protesters in the civil rights lawsuit against the city of Seattle, King County, and state of Washington. At this time, I'd like to hand it over to Gemma.
Hello, everybody. I think when Andrew gave his CLE, he made the similar observation that it's a little bit strange that I can't see any of you and you can see me, but I think I can get past that. I'm doing this ethics CLE in what I hope is a little bit of a substantively unique way compared to many of the ethics CLEs we have attended, where they're extremely boring and theoretical, yeah, they're boring, right? So what I wanted to do was I wanted to pull an actual case study and walk through what happened in the case, what the options were, some of what the solutions were to dealing with potential ethical situations that arose and actual ethical situations that arose. And so what I would love to encourage folks, and I think Cassie is going to be keeping an eye on that on the chat box, and I think you can raise your hand as well. I'd love for folks to contribute their own feedback if they have had specific experiences relevant to this topic, or that touch upon this topic and how they handled it, or what concerns came up in their mind when they encountered these situations, because I think ethics is really fact-based. I mean, we all know there's those obvious black and white situations of things that you never do, and those kind of lie over here, right, in outlier field. And then there's a lot of gray areas where it really depends on the clients, the facts as they present themselves, your own mental or emotional ability to process or partake in representation. And so these things are not simple, right? So back in the day, when I was a youthful baby lawyer, I encountered a situation that honestly I hadn't considered. And since I encountered this situation, I have not looked at a loss of consortium type claim the same. And basically what happened in this case is when we commenced representation of these clients, they were happily married. And they'd been happily married for about 2 decades. And they had a great relationship, but their relationship really devolved over the course of the next few years as my client was dealing with this injury. And we'll talk about that a little bit more. So my client was in a head-on collision, and this is her vehicle, probably not the most, staggering vehicle damage here. But this was her vehicle after the collision. It was a young man who just made an error and caused a head-on collision. And after the fact, the client ended up needing to have multiple levels of her cervical spine fused. So prior to the collision, she had already had a 2-level cervical fusion, and now she needed to have 2 more levels also fused. So she basically had like no range of motion in her neck anymore, and there were, as you could imagine, other complicating factors. So it was not, you know, an extreme level of disability such that she was completely not functional, but it was a pretty serious level of disability and impediment on her life. And it did affect her relationship with her husband and her ability to interact with him and support him in the way that she was able to previously. So like I said, as the years went by, apparently the clients, the husband and the wife, just their relationship changed, their closeness changed. And we were pretty close to trial when my client revealed that they were seeking a divorce. We'd already filed, we had brought a consortium claim for the husband, and you know, we were fairly close to trial when this issue came up. And you know, that sort of blindsided me. This was a client I communicated with very regularly, and I was surprised to learn this, and surprised to learn some of the facts surrounding the decision to go ahead and separate, including allegations of infidelity. There was a lot, and I'm not going to go into, you know, potential, you know, all the gory details of what was or wasn't going on between the clients. What I am mentioning is in the public record, so this is nothing that the clients told me in confidence that I'm now, you know, blabbing out in my ethics CLE, ironically. So there were some infidelity allegations, and there was just apparently an irreparable damage to their relationship. So as soon as I learned that there was a likely divorce impending, it sort of triggered that, you know, that part of your brain that's like, is there now an ethical problem, right? Like, what are the ethical implications of my clients separating or actually divorcing before or after a trial in this case? The other issue is that when they filed their dissolution of marriage, there then were documents in the public record in their marriage file that I was unaware existed. And guess what? Those ended up, of course, being pulled by the defense and slapped into their ER 904, which is, you know, everyone's dream situation, right? This was not a line of rhetoric or dialogue that I was aware of or able to, you know, control in any way, and it was in the public record. Clients did have attorneys. They had family law attorneys. I don't want to be derogatory and call them divorce attorneys, because I don't know what the exact language is there. Someone can correct me in the comments if they know the correct language. So I called the ethics hotline for the bar, and I'm sure everyone's aware that the ethics hotline exists. An interesting fact I found out about the ethics hotline fairly recently is that the ethics hotline advises where you have a potential RPC violation or ethical conundrum, but once you have actually committed the ethical violation or you know, gone into the gray area, or whatever you want to call it, like that hotline is actually no longer available to give you any kind of consulting. So I would suggest that folks use this tool provided by the WSBA and use it preliminarily as soon as you potentially see that there may be a conflict, or, you know, if you're playing the chess game well and you can see 5 steps down that potentially you're facing a conflict, I would recommend you call that hotline and leave a message and talk to them before there's an actual something is actually, the ball is actually started rolling. So what this initially triggered in my mind was whether or not a conflict had developed because of my client's decision to pursue a separation or a formal dissolution of their marriage. And I went ahead and I'm referencing RPC 1.7 here, and some of what I initially kind of talked about with the bar hotline, as well as, you know, within the firm or whatever. So the first question was whether, well, A, you can't represent somebody absent, you know, informed written consent if there is a concurrent conflict of interest. And so question 1 in my mind was whether or not, theoretically, right, on the at the 1,000-foot level, you could actually represent 2 clients who have separated or are having a level of marital turmoil that creates conflict or conflicting interests. And question 1 was whether or not that representation is directly adverse. And ultimately, I think I landed on no, it's not technically directly adverse, right? Because, and my questions were questions like, okay, do we have clients who now have an incentive to be dishonest about each other or their impact on each other, or, you know, how the marital relationship was damaged, or what the actual effects of the injury were? These were some of the questions that I had to run through my mind. And of course, that obvious question, the obvious no-brainer question, which is, okay, if one of my clients does, you know, is giving to one client, taking from another one, and ultimately, when you have a consortium claim that's based on the severity of injury or impact to your other client, I landed on, I don't think that you have an obvious direct adverse, you know, legally adversarial relationship, even if you have an adversarial relationship between these individuals as far as their interactions with each other. But that, you know, that posed its own issue. And the issue was, is kind of highlighted in section B of RPC 1.7, which is whether the lawyer themselves, which in this case was myself and a partner at my firm at the time, whether we believe we can provide competent and diligent representation to each affected client. We had the much more significant relationship with the injured client, not with the spouse. The spouse was actually very uninvolved in representation. He was not somebody that I think I had a couple conversations with him up until this situation arose, and he had his deposition taken and we did that preparation. But other than that, most of the information that I had regarding the consortium claim was coming secondhand through the primary client, for lack of a better word. So where I started to not feel comfortable was here. It was, okay, I know that I'm very familiar with one of these people. I know that there's these allegations of infidelity, and there are some interesting competing interests here. And also, once my client revealed the information about this separation, she revealed that she did not want her husband in the lawsuit at all. So there's another problem, right? She did not want to go to trial where her estranged spouse may be a component of that. And of course, you can prevent that to a certain level, but you can't necessarily prevent you may be able to prevent that individual as a party, but you cannot prevent that individual as a witness necessarily if, for example, the defense chooses to call that person. So my struggle really was around whether or not I felt like I could provide competent and diligent representation to each affected client. And you know, my answer to that was no, I don't feel like I can proceed in diligently representing each of these clients. It was just an extremely uncomfortable situation. And in my mind, putting yourself in that situation and allowing yourself to be representing individuals who are not getting along and have these claims that are, you know, independent, but obviously factually dependent on each other is not an ideal situation. So when you look at the comments of RPC 1.7, one of the things that, you know, that they touch upon is that loyalty and independent judgment are essential elements in your responsibility and relationship with your client. And so this is really what troubled me, is whether I could feel a sense of loyalty and really give true independent judgment to both of these clients, given what I knew about the situation that was going on. So I want to just mention also that RPC 1.8 was potentially an issue in this case, and the reason is I don't know what everyone's experience is on this call, but I have not often received offers in cases, and I had not received an offer in this case that was separated out for a consortium claim versus the just global injury claim itself. And so if we received an offer, and I can't remember specifically what had been exchanged at that point in time, there was not a carve out for consortium. Certainly it's potential to ask for something like that, I suppose you could do that, but our RPC 1.8 came to mind for me when thinking about whether or not this could be negotiated pre-trial, given the parties' potentially adversarial relationship, simply because you know, you can't make an aggregate settlement of claims if you don't have informed consent in writing, and obviously these were individuals who may not be agreeable to a division of funds and in the way they would have previously. And there was, without revealing too much, there was information that I had that would suggest that this would be an issue. So the husband did still want to pursue his loss of consortium claim, despite the allegations of infidelity. I think his position was that you know, the cause of the infidelity was in great part because of the change in the physical nature of the relationship. But yeah, it was something that he felt was deeply impacted, and that was reflected in the dissolution proceedings. Then the question became, well, what do you do, right? If you don't feel like you can now zealously and diligently represent both your clients, what do you do? And so the obvious, you know, the obvious plan of action is, okay, well, I need to withdraw, right? Like I need to withdraw from one or potentially both of my cases. And so when you look at RPC 1.16, you're required to withdraw if you believe the continued representation is going to result in an RPC violation. And then permissively, you can withdraw if you are not going to be causing a material adverse effect on the interests of the client, or if you have a fundamental disagreement with the conduct of the client, or if there's other, you know, the handy catch-all, if there's other good cause here. So in this situation, I think one or both of these, either withdrawal was required, or with a permissive withdrawal was certainly allowed in this situation. You know, unfortunately, we were fairly close to trial when all of this sort of exploded. And so this question here, whether or not withdrawal can be accomplished without a material adverse effect on the interests of one of the clients, became a critical factor, because you can't, you can't withdraw. You can't withdraw a few days before trial and say, good luck, find an attorney on your consortium claim, or whatever way, good luck, both clients, so what we had to do is file for a continuance so that we had time to actually deal with this, so that the parties would be able to secure representation. The clients got independent counsel to advise them on their desires outside of the legal realm. So technically at this time, husband, they were not divorced, had a claim, and he did not want to relinquish the claim. And client A, primary client who was injured, did not want husband in this lawsuit asserting this claim. She felt really strongly about that. And so then the question is, well, what do you do about that? And as the attorney who at one point represented both of these individuals, you can't give advice. You cannot give advice to either one of those people that then creates that adverse effect on either one of them. So at that point, it was, you need to have independent counsel to discuss these factors. And then to also potentially mitigate any adverse effect, I talked to attorneys who I greatly respect and think are great trial lawyers about full withdrawal. I wasn't sure at that point in time, without some additional consultations with the ethics hotline, whether or not I could actually represent anybody going forward. And to anyone who's been in that unenviable position, excuse me, of feeling like you have to withdraw from the case that's like actually good, not, oh, yucky, like this is bad. I called up this other firm and I said, look, we need to get this ethics issue resolved. There's independent counsel involved, et cetera, et cetera. But on the off chance that that doesn't pan out and I can't keep my case, I need to have someone on deck. I talked to the clients about this, about getting referrals to other attorneys. People were on board for this. And so that was, from a human perspective, like really heartbreaking. At this point in time, I had this case for years. I was close to the client. I'd done all the work. It was ready for trial basically at this point in time. And it was just heartbreaking to think I'm going to have to relinquish this person. I feel like I can do the best job trying her case because I've lived this case, and I may have to hand this off to somebody else. But obviously the most important factor for me was that my client have true, diligent, non-conflicted representation. So we had to basically give referral recommendations to both clients. The problem was that consortium case was just not, it wasn't the greatest case. And at that point, you're not going to take those cases on duly. And so really it was husband that was sort of left in the lurch, because he just didn't have a super amazing consortium case at that point in time. Nonetheless, the withdrawal was approved. We did move to withdraw. I think the husband might have objected, but because there was a continuance and there was time for him to potentially secure additional counsel or whatever, there wasn't a material prejudice. And I talked a little bit about this, that you as the lawyer, if you are even if your client fires you, and even if it's a bad gig, right? Like, we still have to, as lawyers, ethically take reasonable steps, all reasonable steps, as we all know, the great objective standard that has no gray area at all, right? Reasonable steps to mitigate the consequences on the client. So what are the things that us as lawyers can do if we do have an ethical situation and we need to withdraw, or the client fires us, to ensure that there's not negative consequences on the client? And I discussed, what I did, some of what I did in this case to attempt to mitigate consequences on the clients, but I'm sure that other folks have taken other steps or had other, factual situations come up. And I'd love to hear them. If you want to type them in the comments or volunteer your thoughts, I would be interested in hearing what folks did in a specific situation that they encountered. So CR 71 is the related court rule that allows you to withdraw. And so, not gonna read this horrifying thing out loud. I think we all know what it is and where to find it. But like I said, my recollection is that this client objected to the withdrawal. I think I'm not going to speculate on why it is that he did that, but he did object to our withdrawal from the case, and that one was just sort of a, not less than ideal situation, and it did withdraw. Ultimately the court allowed us to withdraw, but at that point in time, I felt as though there was a conflict of interest based on ongoing behavior and just how the things had unfolded. I felt like there was a conflict, and I was not going to be able to represent both of these parties, or potentially either one of these parties. So ultimately the court did approve the withdrawal. So then, okay, I don't know how to turn that off, it's just going to ring. So then once the withdrawal was complete for the husband, we withdrew from the husband's case. We didn't end up needing to withdraw from the wife's case. And I'm not going to go into the details of why, because it does involve discussions with the independent counsel. And I don't feel like in a recorded CLE that's really wise to put on the record. But now we had a potential RBC 1.9 issue coming up, right? Because now we have a former client, its husband, and the questions that I had asked myself as a lawyer were whether or not, again, there were interests that were materially adverse in the ongoing injury case to the interests of the former client. Again, I landed on no for this, simply because I did not feel like we were compromising, or I had any information from the former client to compromise a loss of consortium claim by vigorously bringing forth my client's injury claims, because obviously the more impaired and injured she is, the more, I hate to call it a benefit, but the more impactful your loss of consortium claim also is. So I didn't feel like there was a strict issue there. The other thing that ended up happening is that even though husband was vehement that he wanted to pursue his loss of consortium claim, he ultimately decided to non-suit that claim, again, through independent counsel and negotiations with independent counsel. The clients reached an agreement, and husband agreed to drop his consortium claim. So that claim was resolved and gone from the lawsuit by the time we actually hit trial time. It certainly, I think, when considering withdrawing completely from a case versus, withdrawing from one client's case, I think you always have to consider whether or not there is information that you are, obviously intentionally, none of us would ever intend to use information in an adversary way to a former client, but there's inadvertent, right? What's the saying? You can't unring the bell. I think that we come up on this with objections in trial, or you have a bench trial and the judge is looking at all the evidence and then ruling on whether it's admissible. Yeah, I think human beings, we have a delightful over confidence in our own ability to not have bias, or to not process or use or act upon information that we've received, even if logically we say, oh, can't consider that, right? Like that's still in your head. And so, you know, I was really cognizant and thought a lot about whether or not there would be information relating to the representation of the client that during that actual relationship that I would be somehow using to his disadvantage. And I think where the balance fell on that was mainly because I had so few interactions with this individual that I really had almost no independent information from him, and certainly nothing that would be unhelpful, because the body of my interactions with him were, while their relationship was not on the rocks, you know, his deposition happened long before the initiation of the divorce proceedings, etc. So I didn't feel like I had we didn't have his medical records, nothing like that. So I didn't feel like I had access to a lot of just information about him, period. So I didn't, ultimately the decision was that we could continue to ethically represent the injured client without doing any damage to the client with the potential loss of consortium claim, but that it would not be appropriate to continue to represent them both going forward. So just a little bit about loss of consortium. As we know, it's a derivative claim, so it doesn't have to be brought jointly. Technically, the spouse would have been able to pursue his claim in a completely separate lawsuit if that had been the decision. And interestingly, loss of consortium claims may not accrue at the same time as an injury. They accrue when the actual loss of consortium begins. If someone is not aware that there's an issue or that they are losing consortium, for lack of a better word, they may have, the loss of consortium claim may actually have a different statute of limitations, and it may accrue or be viable at a different period of time than the actual underlying injury claim. So these consortium claims are completely independent. And because of that, you know, you don't necessarily have to represent both individuals, even if there is a viable consortium claim. And then of course, consortium claims are valid only for spouses or registered domestic partners. And so, you know, there's an interesting question ethically there as well, because a divorce, an actual legal divorce, is going to impact whether or not a party actually has a loss of consortium claim and the duration of that claim. And so certainly when considering, you know, clients who are struggling or going or having marital troubles, or my clients who'd actually filed this divorce paperwork, can you even tell these individuals, hey, if you get this divorce, it's going to affect claims in this lawsuit, right? Like, I don't know that you can give that advice when you have clients who are in that adversarial relationship. So these were just, again, some of the practical things that cropped up as a result of this impending divorce. So here's the WPI on the loss of consortium claim on the measure of damages here. And again, as you can see, you need to be married. If you have this claim, it has to be for the period of time that you're actually in your marriage. So after dealing with this conundrum, and this case ultimately resolved the night before trial. And I did include in the materials some of the motions in limine that I filed in this case because the divorce situation came up and there was, you know, these lurid details in the public record in the divorce file and those types of things. You know, if I could go back and do this again, I would have focus group this issue because I don't know at the end of the day how the spouse's behaviors and alleged infidelity and that type of thing would have affected either case, right? I did not focus group this. I probably should have, although frankly, that wasn't like the top consideration or priority in my mind at this time. My gut reaction for trial was to get out, keep out. Now that the husband's claim was resolved, and we were going forward just on a single client injury claim, my gut was keep out the divorce and the drama and the crap, and like do not have that in your lawsuit if you can avoid it. It's just going to create complicating factors. So I did have a series of MILs and I did include those in the materials as to trying to narrow and substantively limit those topics at actual trial. So what the jury would be able to consider would be a lesser scope. And so we never played that out fully because again, like I said, there was a resolution shortly before trial. But going forward from this event, this super fun situation, I just sort of formulated some practical considerations going forward. And the first one is where someone is alive but injured, do you take the consortium case? Because I don't think I'm the only attorney in this Zoom room who has had clients separate or have serious marital troubles during or after the lawsuit, right? So do you take a consortium case at all? Or do you simply say, sorry, I'm not going to represent both spouses because it's just not worth the risk, or it potentially can lead to these ethical considerations or whatever. If you're not taking a hard line no, what are the factors that you're considering when considering taking on a consortium case? Is there a damages threshold? Is there are you taking them only in a case where one spouse has passed away? Are you considering some, like, are you considering some written agreement regarding potential conflicts in the future should the parties not get along or divorce or whatever? Like, what are the factors that you're considering when considering taking on a loss of consortium case? Because in theory, almost any injury suit has some consortium element if there is a spouse or a child, but we're talking about spouses today involved. So where are the lines? Like, where are we drawing the lines? Are we thinking about that when we're taking these cases on? I think sometimes these are the things we don't hardcore think about because you're dealing with folks who are really injured. There's other pressing issues, and here they come with their spouse, and they have had or have a loving relationship, and there's serious damage to that relationship. Do you turn that case down? Do you refer it out to someone you trust? How do you handle that? What about communication during the case with your clients? What does that look like? Again, I don't think I'm the only one in this room who has had clients just not tell you something that you're like, that seems like a no-brainer to have told me. And I found that sometimes I only get information from a client if I ask a question in a specific way. And I don't think folks are intentionally hiding things from me. I think sometimes the thing doesn't come to mind until you ask in a specific way. So for example, I had a case where I had asked a client to send me all photos and videos, right, of him interacting with his child. And because he also had a loss of consortium case, but it was his child. And he did that, but what he did not send me were all these, he had all these Snapchat messages. I'm going to reveal that I'm very uncool right now because I don't know the Snapchat lingo. But he had all of these like pieces of multimedia in Snapchat that when I had asked for video and pictures, like in his brain did not include stuff on Snapchat for some reason. And so I can't remember how I posed the question, but ultimately he's like, oh, I have all these Snapchat things. And I was like, oh, Jesus. And there was just a wealth of, really lovely photos and videos of him interacting with his son that were very impactful. But that's just an example of, hey, sometimes you have to ask a question the right way. So what does communication look like during a case if you are representing spouses? What's weird and what's like not weird? What's smart lawyering and what's like weird meddling? Is there a line in there? I don't know the answer to that question. I'd certainly be interested in people's thoughts about how, like, what level of involvement or managing or micromanaging you're doing if clients are married and their case is going on for a few years and there's a significant deficit. And I would be absolutely curious to hear what other considerations folks are looking into, or what concerns or body of relevant factors you're looking at, if before, during, or after you work on a case that involves a loss of consortium claim. So that is that's what I have for the main presentation. I'm certainly open to any thoughts, comments, or questions that folks might have regarding this topic. Again, I think that ethical discussions are really important to our ability to practice and fine tune our practice.
Gemma, this is Cassie. Catherine Mason put a question in the chat. I don't know if you can see it, or Catherine, if you feel comfortable coming on mic and asking that question. I just gave you microphone. There we go.
Okay. Hey, am I there? Gemma, can you give me a thumbs up or something if you can hear me? Okay, awesome. Okay, so I put in a very long question because why not, right? So I have a client with an open and ongoing claim. So, and he and his wife have been married for quite some time. He tells me in early January that his wife has asked for a divorce. I explained to him, how things are going to change just a little bit because his wife had been very active in helping run things from day to day. And then he calls 2 weeks later and says, now they're going to try to work it out. And I'm just reluctant and a little concerned about ongoing communication with the spouse. Previously, of course, it had been carte blanche, include her with everything, make sure she knows things. He's competent and he's got a head injury, but it's not a catastrophic head injury. So, her help has been really, I don't know if critical, but we'll call it critical for the sake of argument. I'm just concerned about ongoing communications and case resolution because spouses have some, survivor benefits in my universe. And I just wouldn't want some of our decision-making to be impacted or maybe used against my client if they decide the divorce is back on. So any suggestions or recommendations? There's a million problems with it, I realize, but I'm just curious about sequestering communications, if that's something I should plan on doing, or just, it's kind of like when your girlfriend gets in a fight with her boyfriend, right? And she wants to talk to you and tell you all the rotten things about him, and then they get back together, and then you're stuck at a dinner table.
The things.
Yes.
You were told.
So anyway, obviously more serious than that, but I'm feeling a bit conflicted, I guess.
Yeah, definitely. I think first and foremost, you are able to, like, clients are able to waive potential conflicts of interest in writing. And so, I would look at those RPCs and consider whether or not you want to have this discussion with your client in writing, talking about the fact that this sort of continued back and forth between these permissions may ultimately be in his detriment. And if that's something that he wishes to do, I think at some point it rises to the issue that you would want to get a potential conflict waiver just to be err on the side of caution there. Because yeah, I feel like a lot of these situations, it's like you don't have a crystal ball, but when you're trying to play the chess game and look down the road, it's like, okay, protecting our clients isn't just about getting a recovery. It's also about protecting them from future harm and the errors of their own decision. But ultimately, I think in this case, the client, if you advise this client as to what the potential consequences are of continuing to allow this level of communication, and like I said, you put it in writing, I think that you're covering your bases, because ultimately you don't represent both people, and you need to, and your client is an adult and he can make those decisions about cost benefit analysis as long as you have provided it. That said, and I'm sure someone knows this off the top of their head, because I know there are very smart people on this CLE. There's also potentially issues with the spousal privilege if he does decide to get that divorce. And I can't off the top of my head remember when the spousal privilege actually ends and what body of information that it contains there. And obviously I know that both people can potentially waive their spousal privilege, but nonetheless, that sort of just pings in my mind as something that you might want to just kind of pop in and do a little bit of research on, just to see if there's anything that you would want to advise the client on there. But anytime and we all have had those cases too, where you're talking to somebody who's not strictly your client. Anytime I have that situation, I do have a specific conversation with my client about attorney-client privilege issues that may be implicated, as well as, any of these other factors that crop up. And of course, you have a situation where now you have potentially an adversarial relationship crop up, which is just, expected but unexpected, right?
Yep. Well, thanks. You've given me some more things to think about. And if anyone else, of course, has anything to contribute, I am all ears for sure. So anyway, thanks.
Yeah. Any other thoughts or questions? Does anyone have an anecdote they would like to share? I know, it's always sharing our own run-ins with the RPCs are not always like super fun to do. I had that thought myself when I was like, yeah, I learned a lot by having this situation crop up in this case, but you also just have to put it out there and be like, yeah, guess what? I didn't anticipate this happening and I had to do some unwinding. And as professionals, that's always a little bit awkward to talk about, I think. So if anyone has thoughts, I'd love to hear them, or other questions. Okay, I think let's see if we have something. Oh, you are welcome. Anybody else?
We have Alexander.
Okay, great. Hi. Alexander, if you're speaking, I can't hear you because you are on mute. And if you're not speaking, I also can't hear you.
Okay, maybe not.
Okay. Zoom technical issues. Okay, anybody else have any thoughts or questions before we wrap it up today? Yes, I agree. A consortium claim does not, I believe that should say that belong in every case, is what you're saying, Mark. I would agree with you. A consortium claim does not belong in every case. And I think ultimately we need to carefully consider whether or not we want to have a consortium claim in a case.
Just, can you hear me?
Yes, I can hear you.
I would just say one thing that I learned many years ago in a very significant case that I did with Jan Peterson. And I think it's as important to remember. I think jurors have an expectation in many instances that, you know, they look at the marriage vows, you know, and for better or for worse, you know, and if someone is injured, you know, you stick with them and you stick through it. And it doesn't necessarily mean that it translates into a claim for money. That there are certain circumstances where the damage, the particular injury may be so specific and so devastating to the relationship between the couple that it's important to bring the claim because it really is it's a very major element in the case, but it doesn't belong in every case. And even if there is a consortium claim, sometimes it's best to counsel the couple that, you know, it doesn't necessarily meet with jurors' expectations about what a marriage is and what parties can be expected to endure without asking for money for it. So
I agree 100%, Mark, and that, you know, this was my lesson on that. And, you know, whether or not, like, do you want to bring that regardless of whether people get divorced at the end of the day? This was my first experience where I really thought about that, where it was like this injury was bad, but it was not the catastrophic brain injury where this person is, you know, completely doesn't recognize their spouse, and it's just a completely heartbreaking situation, right? And that's why, you know, in these practical considerations, consideration one is, do you want to go there? Like, do you want to bring this consortium claim even in a case where there is a significant injury? Certainly not in one where there's, you know, an insignificant injury. And does that consideration, as Mark astutely pointed out, impact your underlying injury case? Because if you've got a spouse who's just there with a handout saying, give me money, like, I'm very damaged and I give these vows, and I was chatting with Cassie about that, but actually beforehand, because she was asking what consortium was. It's like, we do sign up for better or worse. And then here you are saying, okay, I've got, you know, I want a bunch of money. Like, how does that impact your underlying injury claim? Just what's the jury's impression of that, whether your clients have a divorce or not? I think those are wonderful points, Mark. And then Daniel, you contributed here in the comments. I think the loss of consortium claim won't add much, or I think it won't add much, it will detract off and tell them I'll only represent the primarily injured spouse, and then I usually get no pushback. Yeah, absolutely. The interesting thing is, if you have an individual coming in and the individual is injured and they have a spouse, I don't think you have a duty to advise the spouse that they have potentially a loss of consortium claim, because the spouse is not engaging you for legal advice, and you don't represent the spouse until you represent the spouse. I'd be curious if other folks think that's not the way they handle it, but you know, you don't have a duty until you have a duty to somebody to give them advice. And these consortium claims are their own interesting beast because they are completely independent. So theoretically, they stand on their own. They just need the facts of the underlying case. Daniel says he would always tell them they have a potential claim and to seek independent counsel if I don't want that claim. Is that something you're saying literally anytime somebody has a spouse, whether, you know, if it's, you know, you had whiplash and if they were good in 2 weeks, you're still telling them that? He says, yeah. So that certainly seems like good practice to me.
I don't know about that.
Yeah, and again,
I think you have to really probe the clients. You have to really interview them closely to see really what the quality of that, of the relationship is and what that claim is about. I don't think it's a given in every case. And you can certainly add the claim later if you speak to family members or neighbors or other potential witnesses who can help develop it, and help shape what this couple's relationship is and what it was like. But I disagree that it belongs in every case, even by way of potential advice. It doesn't rise to that level to me in every case.
That's a good, and Daniel raises another interesting point where if you have a limited body of insurance and you're now telling a spouse who you don't represent that they may have a claim on that same insurance policy, thus potentially reducing your client
Right on.
Claim itself, are you now creating a ethical issue because you are doing something that may be adverse to your actual client's interests? And that's a really great point and a really good question. And that, that's why I find this topic so interesting, because you don't have to have an adversarial relationship between your clients in order to have adversarial interests in mind, or quasi-adversarial, right? And we definitely see these issues where you have a limited body of money. That's a great point. Yeah. Any other thoughts, folks? This has been really great additional discussion. I definitely appreciate this.
Excellent discussion.
Yeah, great. Thanks everybody for your participation today. I know ethics, again, isn't always the most sexy topic, but yeah, I agree with you, Daniel. Yeah, that's the interesting thing, is that when you have spouses who love each other and are in great relationships, they're much more likely to engage in a give or take, or be more willing to forego their consortium claim than they are once things become adversarial. And that's what happened in my case, was that, yeah. And it really was the moment, and I was, a baby lawyer, and I had not encountered this yet, where I thought, you don't just tack on a loss of consortium claim. Like, you really need to think about whether it's viable, whether it is going to impact the underlying case, and then whether or not you can take on the risk factor, or how you advise your client when you do consider divorce. So yeah, I think that these are a variety of factors that we should consider if we're looking at these consortium claims. And Daniel has helpfully said we have 1 minute, so I think we are at our time here.